All right, Friday. Federal judge issues an arrest order. Not routine. U.S. Marshals, 3 Trump administration attorneys, official court documents. I've been going through the filings dropped yesterday. Here's what happened. Judge Tanya Chutkan, D.C. District Court, gave them until Thursday to comply with the discovery order. They didn't. Friday morning, contempt ruling. Afternoon, Marshal directive. According to the court transcript, quote, "The court's patience has expired. $2.7 million in potential sanctions, 47 sealed documents still missing, 4 days past deadline." This isn't headlines, this is the actual order. Let me show you what's in it. Quick context. The attorney's former White House counsel office names juridical staff who worked the January cases back in 2024 to 2025. The issue? Congressional subpoena compliance case that's been dragging since early 2025. Timeline, fast version. Last year's House Select Committee issues subpoenas for internal White House communications regarding executive privilege claims. Early 2026 case moves to federal court after executive privilege assertions get challenged. 3 weeks ago, judge orders production of documents with privilege log by June 17th. That's the setup. Now the documents. What makes this different? It's not about Trump directly. It's about attorneys who worked for the administration refusing court orders in an ongoing legislative oversight case. Civil contempt, not criminal. Yet. The distinction matters because civil contempt is about forcing compliance. Criminal contempt is punishment. Right now, civil. But the filing suggests that could change. Judge Chutkan has history here. Same judge who handled multiple January 6th cases, known for strict adherence to deadlines. These attorneys knew that. Okay, the evidence. First document, filed Friday. I pulled page 14. It says, quoting here, "Respondents have willfully disregarded 3 separate court directives without adequate legal justification." That's not my take. That's the court order. What it means? They didn't just miss a deadline. They ignored the judge 3 times. But here's what got me. Page 23, different section. The timeline of communication between the court and defense counsel. June 12th, court clerk sends deadline reminder. June 16th, defense requests 48-hour extension citing document review complications. June 17th, judge grants extension to June 18th, 11:59 p.m. June 18th, nothing filed. June 19th, defense counsel emails at 9:47 a.m. claiming technical difficulties with electronic filing system. Put those together, yeah, pattern of delay tactics. I went through this twice. The claim about technical difficulties, court's IT department verified no system issues that day. That's in Exhibit F. So we've got 3 missed deadlines, 1 granted extension, contradicted excuse about filing system, all documented. Now, what nobody's covering. Page 31 mentions a sealed chamber conference from Wednesday. During that conference, defense counsel apparently told the judge they'd have substantial compliance by Thursday morning. Read that again. Substantial compliance. Not full compliance, substantial. Judge's response in the transcript, substantial is not sufficient. The order requires complete production. That changes this because it shows they were negotiating down their obligations in private, then still didn't deliver even the reduced version. Fallout. First contempt finding entered Friday at 2:17 p.m. Second, Marshal directive issued at 3:45 p.m., giving attorneys until 5 p.m. to appear voluntarily. Third, by Saturday morning, all 3 had legal representation and were negotiating surrender terms within 24 hours. Here's the financial piece. The $2.7 million I mentioned, that's not random. Court calculated it as $30,000 per day per attorney, dating back to the original June 17th deadline. 3 attorneys, 4 days overdue by Friday, compounding daily until compliance. Math, $90,000 per day times 4 days equals $360,000 so far. But the order says sanctions continue accruing at $90,000 per day until full compliance. If they don't produce by Monday, $450,000 total. By Wednesday, $630,000. The $2.7 million figure appears to be the court's projection if this goes 2 more weeks. Now here's what caught legal observers off guard. Page 8 of the order specifically authorizes marshals to, quote, secure the physical presence of respondents for purposes of compelling testimony regarding document location and custody. That's not just about showing up to court. That's about forcing them to answer questions under oath about where the documents are. Former federal prosecutor Barbara McQuaid called it, quote, an aggressive but legally sound escalation. The documents show a judge who gave multiple chances, got played, and responded with procedural force. That's just what's public from Friday's filing. More documents dropped Saturday that change the picture again. Subscribe, I'm tracking every filing on this. Okay, but look, gotta be fair here. The defense attorneys have a point. Few points, actually. Their legal team says this is executive privilege overreach. And honestly, the constitutional argument isn't frivolous. Their position, first, these are communications involving presidential advisors during active constitutional crisis management. Executive privilege, historically, protects exactly this type of internal deliberation. Second, the select committee that issued the original subpoena dissolved in January 2025 when the new Congress seated. They argue the legal authority for the underlying demand ended then. Third, they're not refusing to comply, they're litigating the scope of what must be produced while protecting legitimate privilege claims. Constitutional law professor Jonathan Turley put it this way: contempt for litigating privilege is a dangerous precedent that chills executive branch autonomy. Don't agree with all of it, but that's not nothing. What they've got, Supreme Court precedent in Nixon versus GSA recognizing post-presidency executive privilege. Appellate cases supporting deliberative process protection. Even the Congressional Research Service analysis from March admits the boundaries of post-administration privilege claims remain constitutionally unsettled. Their best argument is this: they filed a privilege log identifying 47 documents. That's compliance with the technical requirement. The fight is over whether those privilege claims are valid. Judge Chutkan rejected that, but 3 appellate judges might see it differently. Here's their timeline version. They've been working through 840,000 pages of material with a 6-lawyer team since February. That's roughly 23,000 pages per attorney per month while maintaining other cases. The June 17th deadline, they claim, was procedurally impossible given the volume and complexity of privilege determinations. They requested a 30-day extension in May. Judge gave them 2 weeks, then another 48 hours, then rejected another extension. Their position: we're not defying the court, we're drowning in the workload. And look, I'm not here to tell you who's right. Judge Chutkan's interpretation: you don't get to ignore deadlines because the work is hard. Evidence supports that view. Defense interpretation: impossible deadlines violate due process. There's case law supporting that too. Both can be true. That's what makes this complicated. What I can tell you, what the procedural record shows, and it shows the defense had multiple opportunities to request adequate time in February and March. They waited until May. That undermines their impossible timeline argument. But their constitutional claims about executive privilege, those survive regardless of contempt findings. This isn't really about whether they're lazy or defiant. It's about whether a federal judge can force immediate disclosure of potentially privileged executive communications through contempt sanctions. The answer to that question isn't settled. This didn't come out of nowhere. Backstory quick. 18 months ago, Congressional Committee investigating executive branch communications during the 2024 election certification issues initial preservation notices. 1 year ago, after administration change, subpoenas go out to former White House staff and attorneys. 10 months ago, first privilege claims filed. Court litigation begins. Someone even said on record back in September 2025, this will end up at the Supreme Court one way or another. That was former Attorney General Eric Holder talking about the structural constitutional issue. What happened? Delays at every procedural stage. Pattern. Extension requests filed days before every deadline. Privilege logs amended multiple times. Emergency stays sought at appellate level twice. Every time, judge allowed additional time with warnings until the June 17th deadline. What changed Judge Chutkan's approach appears to be the sealed conference on June 17th, where defense counsel promised substantial compliance by June 18th, then delivered nothing. That's when patience ended. The Marshal order isn't just about these 3 attorneys. It's a signal to 15 other former administration officials with pending subpoena litigation. Extensions are over. Deadline enforcement starts now. See where this is going? This is about way more than 3 attorneys. Like this if the bigger picture is clicking. Friday, 2:17 p.m. Here's what happened. Judge Chutkan issues the contempt order from the bench during an emergency hearing. Quote, "The court's authority depends on parties' compliance with its orders." Courtroom went silent. What followed? Order entered into record immediately. Marshal directive issued within 90 minutes. Defense attorneys notified by 4:15 p.m. 3 hours. That fast. Now, what everyone missed, while people focused on the arrest order, something else happened in paragraph 12 of the written ruling. Judge authorized the U.S. Attorney's Office to begin criminal contempt evaluation. That's separate from civil contempt. Criminal contempt means potential jail time, not just fines. Then the 5 p.m. voluntary surrender deadline passed. All 3 attorneys were unreachable, according to court staff attempts at contact. By 6:30 p.m., their newly retained counsel contacted the court proposing Monday morning surrender. Judge Chutkan's response? Accepted the Monday timeline, but increased the daily sanction to $50,000 per attorney starting Saturday. Wasn't reactive, calculated. You can see it in the sanction structure. Original, $30,000 per day. After missed surrender, $50,000 per day. Pattern, non-compliance becomes exponentially expensive. This is where it gets interesting. By Saturday afternoon, 2 of the 3 attorneys filed emergency motions seeking stay of the contempt order pending appeal. The motions cite Fourth Circuit precedent on executive privilege and argue the Marshal order creates irreparable harm to constitutional separation of powers. They're not wrong that arrest of executive branch lawyers over privilege disputes is unprecedented in modern times. But Judge Chutkan's ruling anticipated that argument. Page 19. Separation of powers does not grant immunity from judicial process for those who defy lawful court orders. She's daring them to appeal. And they're taking the dare. Don't go anywhere. The Saturday filings I haven't shown you yet completely reframe what this is actually about. Stay with me. What are legal experts saying? Former Assistant U.S. Attorney for D.C. Glenn Kirshner, 12 years prosecuting contempt cases. Judge Chutkan followed the textbook progression for civil contempt enforcement. Plain English, she did this by the book. Another perspective, former White House counsel under Obama, Bob Bauer. The executive privilege claims deserve appellate review before contempt sanctions attach. Key there, even critics of the delay tactics think the constitutional issue is real. Here's what's interesting. Even national security law professor Steve Vladeck, who usually sides with congressional oversight powers, admits the compressed timeline does raise due process questions worth examining. When legal minds across the spectrum agree the timeline was aggressive, pay attention. But here's the consensus among former federal judges I'm seeing. Former District Judge Nancy Gertner. Once a judge grants extensions and they're ignored, contempt is the only tool left. And former Circuit Judge J. Michael Ludig. The constitutional claims don't excuse procedural defiance during active litigation. Different perspectives, but common ground. The privilege claims have legal merit for appeal. The delay tactics undermined those claims. Contempt was procedurally appropriate given the pattern. That's where professionals land. The outlier view comes from former Solicitor General Paul Clement, who argues arrests should never be the remedy for document production disputes involving executive branch lawyers. His position, there are less coercive ways to handle this. But even Clement concedes the respondents' litigation strategy invited this outcome. Translation, they played aggressive, judge responded aggressively. Constitutional law professor Lawrence Tribe maybe said it best. Both sides are right and both are wrong. That's why we have appeals courts. This is headed up the chain. Useful breakdown so far? Like it? Helps me know this format works. Why should you care? Real talk, how this affects actual people. Precedent. If you've ever been in any legal dispute, pay attention. What happens when judges can enforce compliance through immediate arrest for civil contempt? Your timeline. Next time you're involved in litigation, divorce, business dispute, whatever, and a document deadline gets set, this case changes the calculus. Miss the deadline? Judge now has precedent for aggressive enforcement. Not dramatic. That's how precedent works. Quick example. You're in a custody case. Judge orders financial records by a certain date. You miss it because your accountant was slow. Pre-2026, judge probably grants extension, maybe small fine. Post this ruling, judge has case law supporting contempt sanctions immediately. Rules changed. Executive branch. Right now, roughly 230 former administration officials from the previous administration are involved in various oversight investigations. Congressional committees are watching this case closely. If Chutkan's order stands on appeal, timeline for every pending subpoena case accelerates. Former officials already lawyering up. Legal fees hitting $15,000 to $40,000 per month for complex privilege litigation. Many don't have personal wealth to sustain that. Money. If you work in government at senior levels, here's your reality now. Legal defense funds. They're everywhere in DC. Current going rate for executive privilege litigation, $250,000 to $850,000 through appeals. Your government salary doesn't cover that. What informed people doing? Setting up legal defense funds while still in office. Not advice, just what I'm seeing among senior officials. Political. This hits both parties. Right now, it's former Trump administration officials. Next administration, same playbook available. Every president's team generates privileged communications. Every Congress has oversight power. The precedent here works both directions. What nobody wants to say, if you work in federal government at GS-15 level or above, you're potentially part of future congressional investigations, no matter who you worked for. Not trying to scare you, that's what the expansion of oversight investigations over the last decade suggests. Practical. What people in government affairs doing now, document everything with assumption of future disclosure. Separate personal and professional communications strictly. Ask lawyers, is this conversation privileged before having it? Knowledge helps. Common person angle. If you pay federal taxes, $2.7 million in sanctions doesn't disappear. If these attorneys can't pay, taxpayer-funded legal defense potentially covers federal employees for actions within scope of employment. That legal question isn't settled yet. But your money might be paying for both sides of this fight. Congressional legal budget, $170 million annually. Executive branch legal defense, classified, but estimated at $400 million plus across departments. You fund both. How'd the attorneys respond? Made it worse, honestly. Saturday morning, their new legal team filed a 67-page emergency motion. Normally, that's fine, but they filed it with the DC Circuit Court of Appeals, not with Judge Chutkan first. That's called going over the judge's head. Quote from the motion: "The district court has created a constitutional crisis requiring immediate appellate intervention." Reaction from legal community? Former prosecutors calling it procedurally aggressive. Law professors noting it escalates rather than de-escalates. Judge Chutkan saw the appellate filing Saturday afternoon. She responded by issuing a supplemental order Sunday morning, today, denying any further extensions and setting a Monday 9 a.m. compliance hearing. Counter from the appellate filing: respondents respectfully request emergency stay of all district court proceedings pending constitutional review. They're asking the appeals court to freeze everything Judge Chutkan ordered. Then this morning, the U.S. Attorney's Office filed its own response, supporting Judge Chutkan's contempt order. Their filing includes a timeline showing 14 separate opportunities the defense had to raise workload concerns. Not cooling down, heating up. The appellate panel assigned to hear the emergency stay request randomly selected Friday. 3 judges, 2 appointed by Democratic presidents, 1 Republican appointee. Oral arguments potentially as early as Tuesday. What's still unclear? 1, whether the 47 documents actually exist in accessible form, or if they've been destroyed and attorneys are avoiding saying so. 2, why specifically these 3 attorneys are being targeted when 11 others worked on the same matters. Coming, Monday 9 a.m. compliance hearing before Judge Chutkan. Attorneys must appear in person. Tuesday or Wednesday, DC Circuit likely to rule on emergency stay motion. Thursday, June 25th, if no stay granted, Marshal directive becomes enforceable again. Date to watch, June 28th. That's when the House Oversight Committee has scheduled a hearing on judicial overreach in congressional investigations. Timing's not coincidental. If arrests happen before then, that hearing becomes a political firestorm. If the appeals court stays everything, the hearing becomes about judicial restraint versus congressional authority. Either way, this escalates. Whether any of the 3 attorneys will flip and comply individually to avoid sanctions. If one breaks ranks and produces documents, the other 2's position collapses. Should know more by Wednesday. Subscribe. Monday's hearing is going to move this forward fast, and I'll break down what happens, notifications on if you want the update. Where we are right now, 3 attorneys facing contempt sanctions, $50,000 per day each. Emergency appellate stay motion pending. Criminal contempt evaluation authorized. Marshal arrest authority active but paused until Monday hearing. Scheduled Monday, June 22nd, 9 a.m. Mandatory compliance hearing, U.S. District Court. Tuesday, June 23rd, estimated DC Circuit ruling on stay motion. Thursday, June 25th, current enforcement deadline if no stay granted. Friday, June 26th, sanctions reach $750,000 total if no compliance. Not public yet whether any settlement negotiations happening behind scenes. Judge Chutkan's clerk told reporters Saturday no chambers conferences scheduled. But that doesn't mean informal talks aren't occurring. Also developing, at least 6 other former administration officials with pending subpoena cases filed notice Friday that they're watching this case for precedential implications. That's legal speak for, we're preparing to use whatever happens here in our own cases. Clock's running. As of this morning, total accrued sanctions, $300,000. By Monday morning, $450,000. If this goes to Thursday without compliance, $900,000. The financial pressure is real and increasing. That's where we are. 3 attorneys, facing arrest authorization, escalating sanctions, and criminal contempt evaluation. Surface read, they defied a judge and are paying for it. But the constitutional questions they're raising about executive privilege aren't frivolous. And the speed of Judge Chutkan's escalation, while procedurally supported, is unprecedented for civil document disputes. I'll be watching Monday's hearing and how they present themselves. Do they comply and try to fight sanctions on appeal? Do they maintain defiance and force the Marshal issue? Do they produce some documents and claim substantial compliance again? The story's not over. It's still developing. The appellate ruling will tell us whether courts are backing aggressive compliance enforcement or pumping the brakes for constitutional review. Subscribe for the full picture when those rulings drop. Not just headlines, I'll go through the legal orders, the actual arguments, and what it means for the next administration, whoever that is. When Monday's transcript becomes public, I'll break it down. Talk soon.